want to welcome you to the Tennessee Court of Appeals. Your panel this morning consists of Judge Frierson to my right, Judge Davis to my left, and myself, Judge McClarity. I'm sure you're all familiar with the proceedings that we follow in this court. We would ask that the appellant reserve their time as they come up. Let us know how much time they're going to reserve for rebuttal, if any, at that time. Mr. Clerk, are there any preliminary matters we need to consider first?
No, Your Honor.
In that case, will you call the first case, please?
John A. Watson, Jr. v. Watco Communities, LLC, et al.
May it please the court, my name is Roy Barnes and I represent John Watson. I would like to reserve 3 minutes for rebuttal. First, I want to thank you for your grace and permission in allowing an old Georgia white-headed lawyer to come up and represent our client who is before you today.
Just like my grandson used to tell me when I thank him, he said, "Grandpa, just think nothing of it." Okay. Go right ahead.
This is a business dispute. And what's happened is John Watson, who invested with his longtime friend, he's not from Georgia, from Tennessee, just across the line in Walker County, Lafayette, or mispronounced by those French folks as Lafayette, but we call it Lafayette. They invested in an assisted living home up in Sevierville, and it's almost been 20 years ago. And the property is, like most business transaction, a Tennessee operating company by the name of Mountain Brook, a Georgia holding company that owned the real estate named Watco. And things went well. They had planned to get the thing up and running and then sell it. And things went well for many years. And then, in 2016, Jim Coxwell came down with Alzheimer's, a terrible disease that takes out the light of life and makes it difficult to perform daily functions, much less operate a business. Enter his daughter, Cam Shiflett, and more importantly, her husband. And they usurped, we contend, the business from an incompetent Jim Coxwell. Shortly after they did so, they ejected John Watson, who was a 50% owner in the property and in the business. And this litigation ensued in 2 states. Now, the Chancery Court, I filed a dissolution case up in Sevierville. The Chancery Court appointed a receiver, appointed a guardian ad litem for Jim Coxwell. But the receiver allowed Cam and Glenn Shiflett to remain in possession, and while they were in possession, they claimed that they took Jim Coxwell's money and advanced it toward the business without any notes, without any security instrument or anything else. The chancellor initially appointed a special master, and he said, listen, you determine the validity, the amount, and the allocation of which corporation, which LLC, which company incurred the debt. Well, and then Cam Shiflett, operating under power of attorney that was executed in 2020, I'll get to that in just one moment. But 2 years after they had made a claim in the dissolution case for those advanced money, she filed a separate action in the Chancery Court for the same amounts. And so, and this I will fully confess. I said, well, I know the receiver will assert prior suit pending and it's void and it has to be done in the dissolution case, and I know they will examine it. But the receiver agreed to a joint and several judgment against both corporations rather than the ones that just incurred it for almost the full amount. Now, the receiver saw its error and made a motion to modify the consent judgment to take out the joint and several. I made a motion to intervene. It was after judgment. That case came up before you. I believe two of you were on the panel, and you said I was too late. And, you know, I'm a big boy, and I understand that. The law is, however, that does not adjudicate any of the merits. Because as the court, as you have said, when a person, now this is not in the brief, but I will send it to you if it becomes an issue. When a person attempts to intervene in an action and the court denies their motion, the person never becomes a party, is not bound by res judicata or collateral estoppel.
Excuse me for interrupting. Did you indicate that is not in the brief that's been filed, which you just referred?
This case is not, because the issue was not raised. They raised it a little bit saying, well, I'm trying to re-argue the case on the intervention. And I'll be glad to submit it.
Is that something you want us to consider? Is that case something you want us to consider then?
Yes, sir.
Then you will need to send it to us.
I will. Now, here's
without argument.
Sorry?
Without argument.
Oh, yeah, I know. I'll just send it to you. And there's two or three more that's that effect. The chancellor approved a sale of the property. And Cam Shiflett, operating through this power of attorney, was a high bidder, $6.4 million. But the judge, the chancellor, he allowed the void judgment because of the prior suit pending to be a credit. And of course that was unfair. I argued with him, make them pay it in so we can litigate the issue of whether it's a void judgment. And he refused. Now, there are three issues. The void judgment should not have been allowed as credit. The power of attorney by which Cam Shiflett operated was executed while Jim Coxwell was incompetent, and therefore she could not operate by it. And then the third issue, but I'll leave that to the briefs, is he should have allowed me to add some parties when we discovered that Coxwell had executed a fraudulent deed trying to transfer the property that's owned by Watco and Mountain Brook to his own 100% interest to his own irrevocable trust. Now, the credit judgment is void because of prior suit pending. It's the same parties, the same amount that the claim was made on, the same court, so the jurisdiction is the same, and it's not. It should have not been allowed as a credit. Now, if they want to go through, let the special master in the dissolution case, we'll go through and litigate that. But they filed a second suit while the first one was pending, the claim was pending. Now, the only thing they say about that, well, it's not the same parties. It was Watson versus Watco, and this one was Coxwell versus Watco. Two issues there. They're both members of the corporations, and they are therefore privies, and privies are the same party. And this court has held, and I briefed this twice, but this court has held many times that where you have the same cause of action, that substantial similarity of parties is all you need. And I've listed several other cases. Now, the four elements that are met or required for prior suit pending have all been met here. Same party, same amount, same cause of action, same jurisdiction. And there's no question that our case was first filed by 2 years. Second issue is this power of attorney. Cam Shiflett has been operating under this power of attorney for years. The power of attorney was allegedly issued on September 10th, 2020. September 10th. This is all in the record, that what I'm about to tell you. On September the 8th, 2020, Jim Coxwell was examined by a psychologist by the name of Spica, Dr. Spica. He found that Jim Coxwell had the mind of a 7-year-old. And 2 days later, he executed this power of attorney. The second thing is, his lawyers have admitted that he's incompetent during this time. These are the facts that were submitted to the Honorable Trial Court. In 2017, Coxwell was involved in a lawsuit over the Northern District of Alabama. And the district court judge there would not allow the use of a deposition that he made on the basis that he was not shown to be competent. The second thing, in September of 2019, in the companion case in Georgia, the trial court held that he was incompetent, and his counsel at that hearing agreed. And this is in 2019, before September 10th of 2020. The Chancery Court in this case found Coxwell was incompetent and appointed a guardian ad litem in 2021. And then on September the 6th, 2019, Coxwell was scheduled for a deposition. I was going to take his deposition in both this case, the Tennessee case, and the Georgia case. The counsel took the deposition of my client, John Watson, for a half a day. I said, it's time for Mr. Coxwell. Well, he's not going to testify. Why is he not going to testify? And this is on the record. He is incompetent. He is incompetent. And then on November the 4th, 2020, 2 months after the power of attorney, the counsel in a status conference in Georgia admitted he was incompetent. And and I've told you about Dr. Spica. Now my time is fleeting away. And let me just say this. I don't impugn the distinguished chancellor at all. This is a complex case. It's been going on for some time. And I think he was just ready to get rid of the case. He's a distinguished fellow. But this is important to my client. He's in advancing age. He's in failing health, and this was his retirement. And he is about to lose it because of the shenanigans, I suggest to you, that have occurred by Cam and Glenn Shiflin. Thank you.
Thank you. You have your rebuttal time. Yes, sir.
Good morning, Your Honors. Justices of the Court of Appeals, my name is Ryan Gerard of the Knoxville Bar with Quist, Fitzpatrick, and Gerard. I'm representing today Richard Ray, who is the court-appointed receiver in this case. Now, before I sort of get into my argument and my facts, I notice my time hasn't started yet. Sorry about that.
It's expired.
Before I sort of launch into my argument and discussion of the facts, I do need to address some of the issues that were brought up by my esteemed colleague here, specifically with the issues of the power of attorney. Now, I believe, if I remember correctly, that my colleague stated that the findings from Dr. Spica were 2 days before the power of attorney was executed. I do not believe that is the case. I'm looking at the reply brief that was filed by my colleague on page 4, and he states that this finding of Alzheimer's in Dr. Malcolm Spica's determination occurred in 2017. I'm looking at page 4, and then my colleague is citing to the record volume 16 at 2, and then also the record volume 15 at 5. The power of attorney at issue I believe it was drafted on September the 10th, 2020. So there's a 3-year gap there as far as when Dr. Spica did his examination and when this occurred in Alabama versus when the power of attorney was entered into. And as this court is well aware, there are strict requirements as far as trying to strike a power of attorney. Adults, even if they have a diagnosis of dementia or Alzheimer's or some other serious illness that affects their mental faculties, they are still presumed to be able to enter into a contract unless the other side or somebody is able to present clear and convincing evidence that that they had the inability to contract. And in this case, we simply just have a diagnosis of dementia. We have whatever reasons that Mr. Coxwell's attorney decided not to have him testify, but we don't have any sort of diagnosis or any sort of evidence that on the date that he was able to execute it, that he was unable to make those decisions to permit his daughter to act in his financial and medical interest. We don't have testimony from the attorney that drafted the power of attorney. We don't have any testimony from the witnesses. Certainly, Mr. Barnes could have subpoenaed those people and brought them to testify, and that presumably would have provided him the evidence he would need to overturn that power of attorney. But it's just simply not here in this case. We did have a guardian ad litem that was appointed by the judge in order to examine whether Mr. Coxwell's interests were being taken care of, and the guardian ad litem did issue a report, and that's cited in my brief. And Mr. Hill was the guardian ad litem in this matter, and he went through a litany of reasons as to why the power of attorney had never been invalidated to his satisfaction, and he felt like the sale itself was still in Mr. Coxwell's best interest, just reserving the rights of making sure that once the sale went through, that he was still involved to make sure that the property was being operated in Mr. Coxwell's best interests. So really, Mr. Watson in this case has been unable to provide any evidence that meets the burden of proof in this case in order to invalidate the power of attorney, and the arguments that have been presented in this case by the by the appellant should be denied. Now, sort of circling back around to what I was originally going to talk about here, Your Honor, Mr. Ray is the receiver sitting here in the courtroom today. He was appointed by the trial judge in Sevier County in April of 2020. He is also the court-appointed receiver in Georgia for the holding company. I don't remember that particular date, but it was maybe it was about a year or two after he was appointed the trustee in Tennessee. He was appointed the receiver in Georgia. So he is the receiver over both of these entities that together, one is a holding company that owns the property, as Mr. Barnes stated, the other is a company that maintains and operates an assisted living facility. We don't contest that these businesses were owned originally equally by John Watson and James Coxwell. Their business relationship soured, and that resulted in multiple pieces of litigation, including the cases before you now. Ultimately, after the receiver had been serving in his position for some time, this also occurred during COVID, as the court's aware, that delayed some process of trying to get this sale going because it was difficult during that emergency to get onto the premises. But ultimately, he decided that it was in the best interest of both parties to sell the business, whether in pieces or in whole, to some other party, and have that money distributed appropriately. So the court ordered a appraisal to be conducted of the business. That was conducted by James Telleton, and ultimately we had a total value of $5,900,000 for the business. Mr. Ray determined a two-phase sale approach would be the best course of action. Phase one was a sale of the business. Phase two, if phase one didn't succeed, phase two would go into effect, and phase two would be more a sort of a fire sale liquidation of property, not including the business interests. The starting bid was $3 million for assets, $100,000 for goodwill, and we essentially had, probably by the end of it, we had two bidders that got to the final process, Compass Ventures and Coxwell. James Coxwell had been approved essentially as a stalking horse by the court in order to bid. The court also approved his ability to credit bid because, as Mr. Barnes alluded to previously, in the sister case of Coxwell versus Watco 694 Southwest 3D 640, that has already come up before you all, Mr. Coxwell had a substantial credit bid, or had agreed to a substantial repayment of money that had been placed into the business. So Mr. Coxwell was ultimately the winning bid at $6.4 million. Compass Ventures was the backup bid at $6.3 million. And the court approved this entire process. Now, the main argument that I'm making today as to why this whole entire case should be kicked back and dismissed and sent back to the trial court is that really the order at issue from July 22nd, 2024, and that's found at the trial record at 001565, does not specify which issues are final. It's not a final order as required either by the rules of this court or by Tennessee Rules of Civil Procedure 54.02. The order The order itself ordered a sale of the business. It ordered some attorney's fees and some fees for that sale to be approved, but it didn't deal with the final distribution of funds. It doesn't close the case out. As a matter of fact, it orders Mr. Ray to come back after the sale is closed and to make file additional pleadings to distribute funds and to report back to the court the success of the sale. As this court is aware, lack of appellate jurisdiction cannot be waived, and I'm citing the Megan versus U.S. Sprint Communications case. Jurisprudence may be raised sua sponte by this court. Appellate courts only have jurisdiction over final judgments. Nothing else for the trial court to do, essentially, is that standard. Now, Tennessee Rule Civil Procedure 5402 does provide an exception, and that's admittedly why we're here, because that language is in the order. However, the court reviews this, has a dual standard as to whether 54.02 applies. The first is whether there is a final order with respect to the parties, and what is a final order, or what is appropriate with a 5402 certification. Certification is not appropriate where the court ordered the final issue is still inextricably linked with remaining issues not to be decided. And in that case, Your Honor, we still have distribution of funds, we still have the closing of the sale, and as this court's even aware from the appellant's attempt to modify his notice of appeal, there were still additional issues being decided by the trial court, namely the nature of the sale, that the trial judge declined to rule as final because these issues are still before the court. And I think the appellant's attempt to even file this amended notice of appeal indicates to you all that this order is not yet final. The order doesn't eliminate one or more claims, and it is not an express entry of a final judgment by virtue of the fact that final issues were still needing to be determined by the trial court.
Counsel, are
Yes, Your Honor.
there issues, and you said there's issues remaining as to how the funds are to be distributed. Has that not been decided at all, like who gets what? Like how much, percentages?
No, Justice Davis, that has not been decided yet. The sale of the business was just to do the sale to $6.4 million. The funds were to be deposited into the clerk and master of Sevier County, and then the court specifically ordered Mr. Ray to make additional filings with respect to distributions. So that order has not come down yet as far as where the funds are to be distributed. The only funds that are to be distributed by the order are attorney's fees and funds to be distributed to the auctioneer. But as far as funds to be given to Mr. Watson, Mr. Coxwell from the result of the sale, no. And there's been no orders dealing with any sort of unsecured creditors or secured creditors or anything else in this case. So, Your Honor, I'm going to move now to whether or not the court erred in denying the motion to add parties. Admittedly, Mr. Ray never really took a position on those motions that were filed. If you look in the record, we simply didn't address it because, from our standpoint, they really didn't have a bearing on the sale process. Based upon the Phase 1 sale progress, we felt like the actions of Coxwell and Shiflett did not negatively affect the sale. We didn't have any problems getting buyers, and ultimately, again, we got down to a two-bidder process. One was Mr. Coxwell at 6.4, the other was Compass Ventures, who's completely unrelated to this litigation whatsoever, and they were at 6.3 million. So Mr. Ray felt like there was really no effect of Coxwell's and Shiflett's actions, and really there was no need to bring them in. But just addressing that, I did note that was addressed by the amicus brief. And the grant or denial of a motion to amend the pleading is at the sole discretion of the trial court. It's under abuse of discretion standard. And really, we get down to a case, this case started in 2019. Mr. Ray was appointed in April of 2020. We get until 2023, and then Mr. Watson finally decides he wants to add Coxwell and Shiflett into this case. And you can go back and look at the pleadings. There's allegations that Mr. Coxwell had frozen out Mr. Watson from the business from the inception of the case. So the court ruled that, essentially at this point, this case is essentially over. We're getting to a point where we've got a sale of the assets and we're distributing money to creditors, and it's really too late to add additional claims and just keep this litigation going. And Mr. Ray would agree with that sentiment. There's really no reason to add in additional parties. That's just simply going to delay and drag things out any more than it already has, because this is a 2019 case and we're still moving towards the finish line. And the circumstances and evidence support the trial court's decision to deny that motion to add parties. And really, this court should just simply uphold the trial court's ruling, as he did not abuse his discretion as the chancellor in this case. It is also indicated in the amicus brief, the claims that were asserted had already been time barred by the applicable statute of limitations, which is found by Tennessee Code annotated 28-1103. And there's, again, given the history of this case and how long it's been going on and the allegations made, there's really no sort of discovery rule that would save Mr. Watson in this matter. Now, finally, I'm going to come back around to the prior suit pending doctrine that was initially raised by Mr. Watson in this matter. The sister case, as this court's aware, is Coxwell versus Watco Community Systems, LLC. That's found at 694 Southwest 3D 640. And that was a case that was filed by the Shiflets through Mr. Coxwell's power of attorney, and he was suing in order to recover funds that had been paid to the business. These were not only just funds that were paid during the course of the receivership, these were funds that had also been paid prior to it. And as this court issued in the initial summary, it stated that Mr. Watson failed in his attempt to intervene in the lawsuit, and he's now filing this particular lawsuit for suits based in contract, unjust enrichment, in breach of contract. The case that we've got here, Your Honor, is a receivership and a windup of business. These are not the same. These are not the same types of cases, which is why when Mr. Ray moved to consolidate the cases in the first place, Chancellor Fogarty denied that motion because he felt at the time that those were two separate issues to be decided, and that was in his ruling in the sister case. As far as the cases cited in Mr. Watson's reply brief, what you note in those cases, especially the Comcast case, where he talks about privity of the parties, we're really talking about parties whose interests are all aligned. That's not the case that we have here. We have a receiver who's a court-appointed receiver. He doesn't owe it. He's not Mr. Watson's receiver. He's not Mr. Coxwell's receiver. He's the court's receiver. And his duties are to the court, and this is not a case that was necessarily cited in my brief because it was raised in the reply brief, but the receiver's authority is from act of the court, not from the party's suggestion or whose consent he is appointed, and that can be found at Pope v. Industrial Bank, Inc., 173, Tennessee 461. The receiver is a ministerial position of the court, and that is found at KMC Co. v. Neighbors, 572 Southwest 2D 255, Tennessee Court of Appeals case 1977. And what these cases essentially stand for, the fact is that Mr. Ray is not representing Mr. Watson. He's not representing Mr. Coxwell. He doesn't owe them duties. He owes a duty to the court to do the best job as far as administering this business. In this case, it's a windup. All the cases cited for privity of parties by the appellant in this, or by the appellant in this case, Your Honor, they all deal with parties that all have the same interests involved. And clearly, by the litigation, everybody's interests in these cases are disinterested. It would be a disservice to simply say that since these are all closely related together, all the parties are the same, and therefore these two cases are met by the doctrine of prior suit pending. Finally, Your Honor, we also point out in the amicus brief that in the wind-up statute itself, the Tennessee LLCA permits claimants to file separate lawsuits in order to determine their interests in a wind-up case. And that's simply what happened here, and that's found at 48249-611. I notice my time is running out, Your Honor. I would address the final issues to say that if the court did determine that prior suit pending did apply, harmless error would apply, as it would simply go back to the same court, the same judges, and the same decisions would apply. I notice that my time is running out, Your Honor. We would ask that the court affirm the decision of the trial court and simply dismiss the appeal in this case. Thank you, Your Honors.
Thank you. Yes, sir, your rebuttal.
Yes. I remember going to a funeral several years ago, and this fellow that we were going to the funeral with, to a lawyer friend of mine, and he was a lawyer, and he was a reprobate. He was bad to drink, as my daddy would say, and among other things. When we came out of the funeral, I asked my buddy, I said, did we go to the wrong funeral? And I felt the same way listening to the case. We're in two different cases. Let me try to bring back to where we are. First, this Spica being in 2017. On page 9 of our brief, Spica examined him twice once in 2017 and once in 2020, 2 days before. Now, listen, I understand, I didn't mean to say listen, but I understand that we have the burden of proof on incompetency. But we showed all of these facts we've just given to you. They put up not one fact. They didn't put up anything in contradiction of it. So we can't be, what they say, unless you have a witness that was there at the moment of the time and knew his mental capacity, you can't do it. That's not true. That's not true. All of these facts 2 days before, years before, claiming that was the evidence we put up, they didn't rebut it. Now, let me just comment the last time on the guardian ad litem. If you read the guardian ad litem's report here, he said there's no question he's not competent. And he says, but I don't know, I was not there when he executed. Now, let me just say about prior suit pending. The same case was this, it was the same case. He made a claim in the dissolution case that was the same in the suit. And that is the same case by the same parties. Let me just say one last thing, and this is a void judgment. And this business about, well, you don't have standing because it's not final. It's final as to whether you can use a void judgment as a credit. It is void as to the distribution. The court, there's no other, they've put in a time for claims. It's going to be divided 50-50, but my client's only going to get, if he gets anything now, it would surprise me because of this void judgment. It is not harmless, and it is final as to his right for his distribution. And let me just add this on the ad parties. You know the reason we did that? In 2021, he executed these deeds, Coxwell did, illegally. When we found out about it in 2023, we immediately moved to add the parties. Thank you, Honor. We ask that you, Your Honors, we ask that you respectfully reverse the case, remand it with your instructions to the Chancery.
Thank you very much. I want to thank the attorneys for your presentation. These are indeed challenging issues.